requiring the importer of record to exercise reasonable care to ensure that any foreign goods that they present for importation to the United States are imported.
There is no way that you're going to find a technology, map your supply chains, do the screening, and then go through the validations in 30 days. Your products will be gone by then.
Welcome to Simply Trade, brought to you by Global Training Center. My name is Lalo, and together with my co-host, Andy Chavez, we have well over 60 years of combined trade, logistics, and supply chain experience. Along the way, we have seen and experienced different challenges in trade compliance. We decided to put the show together and call on our friends and colleagues in the business to discuss these topics and just hang out with us to shoot the ship on all things trade. Thank you for spending some time with us. Enjoy the show. Hey, I was thinking the other day. You have a daughter, right?
Yes, she's married now.
Okay,
but
yeah. Yeah, and I have a couple of kids, and I was thinking the other day. When they were growing up, you always used to try to have them not associate themselves with a certain group of people.
Oh man, you always worry about that. It's like the influence of some folks that may be a bad influence, right?
Exactly. Yeah. So I don't know. I don't know. Sometimes I'm even thinking I can't imagine, or I can't. I just think back, and maybe I was one of those kids that parents used to say don't hang around with, but who knows? Anyway,
there's a lot of fathers.
I didn't have.
Well, I was going to say there's a lot of fathers that hated to see me coming up the step to pick up their daughters for a date or something. Like, oh no, who's this? But
here comes Andy.
Uh-oh.
Well, anyway, reason I bring that up is just by our kids or whoever hanging around with that crowd. I mean, it's immediate guilty by association type scenario, right?
Yeah,
I mean, you immediately start thinking, hey, they might be up to no good. So how does this relate to trade?
Well, I kind of see where you're going with this. Is that you have some folks in your supply chain, and if they're not of good character, if they're not crossing the T's and dotting the I's for regulations and all that, you yourself could be guilty of by association, right?
That's exactly right. Yeah, and that's why I've lined up a couple of girls here, ladies, really intelligent ladies that are going to be joining us for the podcast today. That we're going to be talking about forced labor, and again, guilty by association. Almost anything that comes out of that Uyghur territory in China, it's almost flagged as automatic
forced labor and slave labor.
Yeah, forced labor, whatever. Yeah. So anyway.
Well, that's the one thing is that with what we've got is the folks that's what are you supposed to do about this? Is that new regulations have taken effect that have been spawned from new legislation. The legislation was passed back in December that we'll be able to talk about today. But also it became effective in June. There's a lot of talk about the Uyghur Forced Labor Prevention Act. So what do you do about it? I mean, that's what we're going to be getting into.
Right. So it's a really good slate that we have here. And you and I talked about these two ladies before, Amy and Anna. Mm-hmm. Very great background. I believe we couldn't have found anyone better than these two ladies.
Amy Morgan has been around a while. Matter of fact, I first met Amy when she was somewhat of a rookie and a trade analyst. Very sharp lady, and she was working for Nordstrom back in those days. Right. And so anyway, she's got a lot of things to talk about as far as how to incorporate some automation into your supply chain and a few other things to approach. And she's actually got hands-on experience with some things. So that's, from an importer's perspective. Ana Hinojosa. You did it. She's going to kill me. I know it.
You did it.
Ana,
You did it.
I am so sorry. I'm like, it's like I keep butchering that, and it's because my elevator just does not make it to the top sometimes.
You made it.
Yeah, there, Ana Hinojosa, right?
Yes, sir. Yes, sir.
Okay, all right. Ana has come from customs and actually was over in Brussels with the WCO for a while, and but representing U.S. Customs and Border Protection. And her knowledge and background is very impressive. Folks, you guys can go and we have show notes that you can look at their bios and just understand this is that both ladies have impressive credentials and experience, or we wouldn't be talking with them. So we're going to be getting into a great show, and hopefully this will be something that you'll get a nugget of knowledge that you can use, become a bit more proficient in this forced labor prevention situation, and secondly, be able to identify the next steps, at least for the next, 1, 2, or 3 steps that you should be taking in verifying your supply chain.
Right. Okay, well, let's bring them on, Andy.
All righty.
Cutting to the chase, we can talk a little bit about the history on this, but people can gather the history. People can get into more of the details. What usually goes lacking is, okay, so Forced Labor Prevention Act, so what? What's the action that somebody needs to take? And as we're going through it, and one of the questions I'll just tell you right now, Ana, one of the things that I saw that has come up several times, and that is people have supplied customs with what they felt was proof that they've checked out their supply chain, there's no forced labor, and customs rejected that. So that's one of those things that is like, okay, what did they supply and what is it you guys were looking for? This is a big deal, not only in the States, obviously, but, in the WCO as a whole across the board. I'm sure that in the WCO conversations, China, possibly even Russia, were fighting you on some of these committees. At the same time, regardless of that, it's come through how people can, when we're sitting here talking, it's like, I've checked out my supply chain as best I can. Ana, why don't you start us off on this segment for the Forced Labor Protection Act? Give us a little bit of a history on, obviously you've got a very impressive background, not only here in the States, but also in Europe with the WCO. That said, you've probably looked at many regulations and proposals and all of that. Tell us a little bit of why this is such a big deal and what's come out of it regarding the regulations.
Well, thank you, Andy. I'll mention that, the issue of forced labor is one that the United States has been focused on or has had laws on the books for a very, very long time. There were some statutes and, before 1930, but the forced labor statutes that we have today is part of the Tariff Act of 1930 under Section 307. I don't want to get too technical on it, but under Section 307. And, for many years, the U.S. had a consumptive demand clause that had evolved due to business interests and had been put onto the Section 307. And what that consumptive demand clause, we're not going to go deep into this, but what that consumptive demand clause said was that it converted the statute to say that the U.S. was to prohibit the importation of any goods produced in whole or in part with forced labor, prison labor, convict labor, forced child labor, etc., unless the U.S. did not manufacture sufficient quantities of those goods to satisfy U.S. consumers' demand. You and I know that over the last 30 years, at least, the U.S. has offshored manufacturing. And so basically almost everything qualifies for that exception. And so since that clause went into effect, enforcement was basically non-existent because everything, practically, fit into that exception. So, over the years, Congress has sought to try to tighten up the statute. And they were successful in doing that in 2016 as part of TIFTIA of 2015, which is a weird misnomer, but as part of TIFTIA, they amended the statute again and removed that consumptive demand clause. And so from that, Customs and Border Protection began taking some enforcement action, building the capability that they didn't have because they weren't able to really take enforcement before. And so they build the capability and start issuing withhold release orders under Section 307 and a few findings as well.
Yeah.
And so the private sector is getting used to kind of what that means and what that process is. Okay, you have a detention for forced labor. What do you have to do to put together an admissibility package? Still a lot of confusion on the part of the private sector. But over the last few years, they've kind of been starting to get their act together in trying to figure out what kinds of supporting documentation, what kind of due diligence they need to undertake with their supply chain. But then Congress felt that there really wasn't enough being done to address the issue of the atrocities that are happening in the Xinjiang the Xinjiang Uyghur Autonomous Region of China. And so because the normal enforcement
and you call that, forgive me for interrupting you. In that region, is that what you call, was it XUA? Is it?
XUAR,
yeah.
because it stands for the Xinjiang Uyghur Autonomous Region. XUAR.
Region.
So,
okay. All right. Yeah. Okay.
So Congress decided that it wasn't enough and that more needed to be done to really make a strong statement. Back in July of 2020, the U.S. government as a whole issued a Xinjiang business advisory, and basically it said, get out of Xinjiang because there's so much forced labor there that you're not going to be able to avoid enforcement. And then in July of 2021, there was an updated Xinjiang business advisory that was issued by the U.S. government. And so there's been a lot of messaging to the public, to the private sector, to other governments that there's a real problem. Obviously, there's a real forced labor problem around the world, but there's a real serious problem of forced labor in this region of China. So fast forward to December of 2021, and Congress successfully passed this Uyghur Forced Labor Prevention Act. And what it does that's different than what the normal 307 enforcement is that it institutes a rebuttable presumption that any goods that are tied in any way to the Xinjiang region are presumed to be made with forced labor until they're proved otherwise. And so that's different than the standards and the thresholds of evidence that CBP might consider when looking to see if they're gonna release the goods. What the enforcement and the provisions that were put in for Xinjiang are modeled after the provisions that the U.S. had in place for dealing with North Korea. So there were already provisions that the U.S. government used to take enforcement action against any goods produced by North Koreans, and that included a rebuttable presumption. So if the U.S. government had indications that there were any North Koreans involved in making those products, then they could prohibit the importation because they were deemed produced with forced labor.
Let's talk about the rebuttable presumption. Is that when somebody brings in today's world, let's take out the controversial countries right now. You just bring in something out of Europe, out of South America, whatever. And as it's coming in, if customs has a question on it, it's assumed that it's valid of what's presented, country of origin, the paperwork and all that. And you can supply, if you will, proof after the fact. Whereas if I've got this correct, and again, understand I'm dumb as a box of rocks here, so you got to simplify this, all right, is that in this particular case, the rebuttable presumption is I have to prove it before it'll be allowed into the commerce.
So
is that valid?
Let me maybe put a little finer point on that. Under the normal process for enforcement for 307, the government, or CBP in particular, has had to conduct an investigation and establish reasonable suspicion that those particular goods are produced with forced labor. and CBP publishes that. They put it on a website. They say, hey, if you buy anything from Amy Morgan's manufacturing, it's going to be detained, and you're going to have to prove that it's not made with forced labor. And so everybody has noticed that that's going to happen. With regards to rebuttable presumption, the U.S. government doesn't have, they have published some, high risk connections, right? As part of the strategy that was published on June 21st, but they don't have to publish anything. They don't have to say anything. They just have to have information that there's a connection. And then because they can establish that connection, then the burden shifts to the importer of record to be able to prove with clear and convincing evidence with a much shorter time frame that those goods are absolutely not made with forced labor or any connection to Xinjiang.
Okay. So
does that
again,
help?
it's more than just, it does. I'm thinking of the supply chain person where, all right, you've got your purchasing, your outsourcing group that is finding a factory for a widget to be manufactured. And as it's going through with the transportation and logistics folks, a lot of times the compliance, and it's paramount that, in my opinion, compliance needs to be included with the logistics and the purchasing folks, and they ought to be joined at the hip. Not always there, but the point being is this. As the information is flowing through, the compliance are going to need to say, this is the information I need to have before it comes in. Otherwise, you're going to be manufacturing a widget, transporting it, exporting it from, China in this case, and importing it into the U.S., and it's going to get held up and potentially either have to be returned or destroyed if that information is, not provided or suspect or whatever.
Yeah, one thing that I think people are maybe confused about is I think that they think that the requirement is new or that the rules are absolutely new. I mean, certainly the Uyghur Forced Labor Prevention Act does put in the rebuttable presumption, which is kind of a new thing. But the issue of how CBP conducts enforcement is foundational. And part of that, and I'm going to get to what I mean by foundational. Right. So our regulations, or the U.S. government's regulations, say, and this was reinforced in 1993 with the passage of the Customs Modernization Act, along with NAFTA, where the burden shifted to the importer of record, requiring the importer of record to exercise reasonable care to ensure that any foreign goods that they present for importation to the United States are in compliance with all laws, rules, and regulations. Everybody agrees that is on the books, that is a requirement. But then how does that get operationalized? Well, that gets operationalized when those goods are presented. Then CBP has 5 days to decide, do I know enough to let these goods in, or do I not know enough to let these goods in? And the do I not know enough, or is there a concern, can be agriculture related, can be FDA related, it can be IPR related, or it could be forced labor related. And so within those 5 days, they say, you know what? I can't let these go because I believe that in this case, that there is a connection with Xinjiang. And so the importer of record receives, along with every normal processing, a detention letter that tells them that they have 30 days to provide clear and convincing evidence because these particular goods are being detained because the U.S. believes that these goods are made with forced labor due to a connection with Xinjiang.
Okay. Now, with that, of what you're saying, and I like the idea that they have at least 5 days to make that decision. Am I going to release it or not? As far as the customs inspector, it's not indefinite. Yet, if they're going to issue a CF-28, I assume, on saying you got 30 days to provide more, is that how they're doing it, or how are they going to?
No. It would be.
How are they? It's just a separate notice.
It's a detention notice. Yeah.
Oh, okay. I'm sorry, I didn't catch that a while ago. All right, so which is a different situation there. Okay. All right. So to that extent, when people have provided in response to the detention notice, what Customs was hopefully in response to what Customs is looking for, and Customs has rejected that. What is it that the people are providing from their companies that is not measuring up?
Well, I'll give you a couple of examples. I can't tell you specifically, but I'll give you a couple of examples of what not to do, right? So in the early days, we
Right.
saw detentions under normal 307. And again, recognizing that 307 actually has a lower bar for evidence than the Uyghur Forced Labor Prevention Act. A shipment would be detained, and a company or the importer record had 90 days, which they still do under a normal withhold release order, had 90 days to provide an admissibility package to try to gain the release of those goods. And then they would send the equivalent, obviously we do so much digitally now, the equivalent of boxes and boxes of boxes of documents, right? The electronic equivalent of that, with no roadmap, with no explanation, with no understanding of, do these documents even relate to the specific goods that are being detained? I don't care what you did 10 years ago or 5 years ago. The evidence that you're providing needs to be very focused on, I have container number XYZ. What's in there is what you need to prove. And then tomorrow when they detain container ABC, it's a whole other package you're going to have to submit for container ABC, because we don't know if that's the same merchandise. We don't know what happened with those goods. It's a whole other admissibility package is submitted by the specific detention. So that's one thing that I would say is, don't send the kitchen sink. You know, be very focused, be very precise about what's detained and what went into the manufacture of those particular goods. The other thing is that.
So let me hang on just a second. So let me rephrase what I just heard just for a second. Okay. Is that the strategy that maybe some would use to inundate Customs with an overload of information, whether it's relevant or not relevant? It sounds like most of it was not relevant. Right. Is not a good strategy in responding to this. Would that be a fair statement?
That's a very fair statement.
Okay. So what's the next thing?
Yeah. The next thing is submit your package as quickly as possible. Obviously, you need to do the research and have your information available before you send the merchandise to the U.S., ideally, because you're not going to have a whole lot of time. You need to submit your package to CBP, and CBP needs to make a decision relatively quick, because up at the 90-day mark, the importer record accrues protest rights, and accrues might not be the right word, but is eligible to file a protest. And CBP can just say, you know what, we haven't had time to review it, so we're excluding it because we can't admit it. We can't determine that it's admissible. So the sooner that the package is submitted, the better. And as it relates to the Uyghur Forced Labor Prevention Act, that time frame is 30 days. So there's no way that you are going to be able to submit a package for any evidence that you haven't already gathered within 30 days. I don't know how that can possibly be done with a Chinese supply chain.
Right.
So definitely the answer is start early, start now. You should have started yesterday, but start now.
Amy, what about automation? Is there, what should people be doing here?
One of the big messages I'm trying to get out is, don't use technology earlier. Don't wait to seek out a solution, because our traditional compliance approaches that we're all used to, policies, procedures, questioning your suppliers and all those things are great and effective, but they're no longer good enough for legislation like this that requires more about your outer tier supply chains, right? And so there's no choice but to use some sort of advanced technology or AI tooling in order to see what you couldn't see before at scale. So if we could spin it more like This isn't something you do after you've analyzed your supply chain. It's something you need to inculcate into the analysis of your supply chain. And that's where that's the awareness I'm really trying to get out there.
Okay.
Does that make sense?
Sure does. With all this information we've been talking about, Amy, let me go to you on this, is that there is so much information that if people are waiting, if you will, kind of like what Ana was saying, waiting till it arrives, there's just not enough time frame in there. Is that there's a lot of information you got to filter through, you got to try and gather, and then put it in a format that will be understandable and acceptable to customers. So in looking at that, there's no way, especially with global companies, national companies, whatever, that have multiple vendors, to wait till the last minute. That's a lot of information to try to keep up with manually. So what do you I guess suggest or think about that a compliance related person and group should be doing in regards to their supply chain here? How to manage it, in other words.
Yeah, so there's three things. It's an awesome question. I've been asked that same question a lot. So there's three things I've been suggesting to people without sounding overly commercial for the company that I work for. The first thing is to think differently or approach what we've considered to be traditional reasonable care or traditional compliance activities.
Okay.
Be open to a new idea. And what I mean by that is all of those recommendations and techniques that we've employed previously, like doing our proper due diligence on our suppliers, revisiting your contract language, documenting your policies and procedures, those are all really great tools to have in our toolbox. But the thing we need to think about now is, now you have to know not only who you're doing business with, so not just your typical supplier questionnaires or whatever, but you need to know who they're doing business with and who they're doing business with. And you just said so yourself. There's too much. You can't do that manually. You have to be able to do that at scale. So there are technologies. It was only within the last 5 years or so that the technology even emerged to make it possible to use artificial intelligence and machine learning techniques to do that, to construct what a company may not know or may not have visibility to, or may have been relying on questionnaires and surveys and manual exercises to obtain previously. So there is technology available now that can do that. So that my first piece of advice would be to just first know that, and two, be open to the idea of using it. I know it can be intimidating to think about how do I as a compliance person or a procurement manager or a supply chain manager employ advanced technologies in my daily life, but it's accessible now, and it's only going to get better. So better to embrace it sooner, or at least be open to that idea. And the second piece of advice would be, with that being said, you could use this new technology to maximize the investment you are already making. So if you have people who are submitting or are managing questionnaires and supplier surveys and audits and all of these things, why not maximize those activities? If you could use technology to construct your multi-tier supply chain without having to manage a questionnaire, without having to manage a survey, that's great. Now you can actually automate the screening of all of those parties against the known entities who are affiliated with forced labor activity, to find out if there's even any exposure, sort of like a restricted party screening tool, but now it's not just your customer or your supplier, it's who they're doing business with and who they're doing business with, right? So now you can automate that, and once you know where you may have that potential exposure, even if it's in your tier 2 or your tier 3, you can take that list of potential exposures, and now you can laser focus any of your manual activities, any of your audit work, if you're working with a lab to validate the origin of the product, you can focus those dollars and those resources on where you have knowledge that there could be risk. Now you're maximizing those investments. So you're not just saying, I'm going to lab test every single one of my products and all of those things. You can focus those dollars. So the third thing I'd say really piggybacks on what Ana was talking about, and that is not to wait. If you wait, until you get a detention notice to employ some sort of technology. There is no way that you're going to find a technology, map your supply chains, do the screening, and then go through the validations in 30 days. Your products will be gone by then. So my advice is to start looking at these new technologies now, employ them to the supply chain that you have in front of you to understand where you may have potential risks today, and then use those same technologies to vet prospective suppliers in the future before you start doing business with them, so that you can take any mitigating action or maybe make a different decision, and you aren't caught in that window of time where you're crunched and you're stressed and you have to do something. I think this is the new compliance normal, right? Like, this is something we're going to have to do. Today it's forced labor. Tomorrow it could be related to having to calculate your carbon emissions, or it could be identifying conflict minerals or cybersecurity. Whatever it is, there's more to come. And you're going to have to know this information in order to comply with those as well. So starting now is the best piece of advice I would give anybody.
Well, it's the compliance realm, in my opinion, has moved and is moving a lot more rapidly, but traditionally it has been very reactive. And what I'm hearing from both of you is that the compliance folks need to be proactive. Now, that's easier said than done.
So that kind of leads me to believe, I mean, with my IT and previous experience, this might be a question for Amy as well, is when importers are doing USMCA, for example, I mean, you way well in advance know it's USMCA because you did your analysis or your bill of materials and everything. So very similar. Instead of bill of materials, you're doing your supply chain. Why not just do it now? I mean, is customs going to head towards or go towards, like, you can have a certificate where you're certifying yourself? I mean, per shipment, or is it just as it hits? I mean, why not just have it right then and there?
I think Customs has made it really, really clear in their guidance and in some of their outreach that certificates of origin, traditional certificates and validations are no longer necessarily acceptable, and they won't necessarily carry the weight that they used to carry, or they still carry when it comes to like trade program or preference program eligibility. So in this case, I would agree with you that just like you would go get your certificate of origin and do your validation and all these things to qualify your goods for the trade program early. In this case, I would say vetting your new suppliers or prospective suppliers, screening them, understanding who they do business with, who they buy their materials from and who they buy their materials from, and knowing whether or not any of those entities have any exposure or potential exposure to known bad actors related to forced labor activity. Knowing that upfront before you make your decisions about who you're going to do business with is a absolute best practice, new best practice, hands down. Because you won't be able to rely on certificates of origin or those validations, audit assessments and things, especially in China, because auditors are no longer allowed. And a lot of auditors are pulling out of China for safety issues, regulatory issues, and whatnot. So absolutely doing it upstream before you do business is a good choice.
On Amy's point, the level of monitoring and observation that is happening, especially in the Xinjiang region, makes any audit really impossible to be an independent audit, because the Chinese government is supervising to a level that it's impossible to have anything be independent.
And what I'm gleaning out of this is the next steps for some people is to take the compliance people have got to become more in a partnership and an alignment with their outsourcing and purchasing group, with their transportation and logistics group, with their marketing areas, believe it or not, and all. And I've personally done seminars where the most effective thing you could do is have a representative from several different departments: marketing, customer service, sales, IT, legal, to compliance, to the purchasing, the transportation, all that, and start talking about these. But it sounds like if you're proactive, you can automate these things in such a manner so that when the goods are actually manufactured and moving, it's not a case now of, oops, we've got, problems. So with that, let me ask is that if somebody comes to you and follows what Amy is saying here, is that they are proactive in helping to become part of the vetting process of a new vendor and goes through that and has appropriate documentation and looks at that. And then they are able to present to you, here's what we've done, here's how we vetted it. We've worked together as a team within our company from several different aspects of different departments. Is that going to be looked at favorably from customs, even if you still have a suspicion, but at least from a due diligence, the company's doing everything they can?
Well, I guess I'll remind you that I don't work for Customs and Border Protection anymore. However,
No,
having
I understand
been there,
that.
having
in your
been
opinion.
there, in my opinion, definitely, I think that CBP is not going to allow anything that they believe is made with forced labor to come into the country. But if they've detained a shipment and they are able to see what the company has done, which, from what Amy was suggesting, they use the technology, a solutions provider like Amy's company, to gain better transparency into the supply chain. I mean, it's no joke that the Chinese government is really kind of clamping down on businesses, even giving supporting documentation to U.S. companies through their foreign sanctions, anti-foreign sanctions law. They're really clamping down. So in some cases, it will be very difficult for a U.S. importer to even see or get information downstream. In the past, it was that importers their manufacturers didn't want to be cut out of a deal. Now it's just that they're going to be sanctioned if they give you more information. So there's different intricacies into why companies aren't giving you the supporting information. But being able to get some of that supply chain transparency through solution providers that have access to broad data, access to artificial intelligence, to be able to connect the dots to see where there's linkages. I mean, there's a lot of changing of names. There's a lot of willful obfuscating of the supply chains, and having this type of solution definitely helps an importer be able to see where their potential risks are, and then to the extent that they need to get further supporting documentation, they can, if it's organic material or things that can be tested through forensic analysis. That's an added layer of certainty that the goods are not made, from that geographic area of the world, and still policing and policing their supply chain. For example, if you are not sourcing anything from China, making sure that none of your suppliers are sourcing anything from that particular region. And you can demonstrate that together with some of these other very important automated tools. I think it will be a very strong package. And even the DHS guidance specifically articulates that there are these tools, because a lot of companies were saying, well, how do I even start? And there are a lot of solution providers like Amy's company that can provide that greater transparency.
Excellent. One of the things I will say that, where do you start? One of the things I go back to the fundamentals on things, and Amy, you touched on something earlier, is, it would be important to integrate the technology from the start to the end of your supply chain and not wait. But with that, to me, as far as a particular action, is starting with making sure that, believe it or not, your bill of lading is synchronized with your commercial invoice. When the paperwork is actually generated, origin vendor / shipper is preparing the paperwork. A lot of that comes from many companies from their the importer of records company, and they're generating a commercial invoice and or bill of lading information. Regardless of the mode of transportation, the bill of lading information should be synchronized with the CI, and then you have special declarations with that. Well, what comes of that is also making sure all the information that is required for an accurate and timely clearance is on that paperwork up front. To get it that far, then it's like, for example, one of the biggest weaknesses of for a compliance person is a new part that is imported and they don't know about it until it hits the import port. Well, a part does not just happen. It takes several weeks, if not months, for a part to be designed, looked at. Okay, we've got a new widget. Marketing, is there a market for it? Can we sell it? While they're doing that, you've got sourcing that's out there trying to find a place to manufacture the item. You have all those things going on, and then it amazes me on how the compliance is left out in the cold until it arrives at the port and everybody's hollering and screaming. It's like, we don't even have it classified. Where's it from? What do we got? So if they get ahead of this, then from what y'all are saying is, I think this would be a smart, it's a working smarter, not harder, and doing, Amy, exactly what you're talking about, being more proactive in the compliance arena.
I'm not going to disagree with anything you just said, Andy. But I wish I could flip into a mode where I'm giving you a demo right now, because I can actually show you how that could look in practice. And one of the things that I've always been passionate about, and anyone out there in the trade circles who knows this, is moving compliance further upstream, making it more organic to the process, less an afterthought like it has been in previous decades. So one of the things that we have applied into our technology is a basic principle of collaboration. Compliance should not be an afterthought, and compliance shouldn't be using different information than procurement or supply chain or sourcing or any of those other groups. So if we're operating off of one source of truth that all the stakeholders can engage in, work with each other on, compliance is no longer that afterthought. Now compliance is woven into the entire process from the very beginning, from screening prospective suppliers to customs clearance, where you started your question. So if that is the case, we're looking at a whole new era and opportunity for trade compliance people. Now, instead of doing the rote work, and I don't mean rote to be disrespectful, they started my career as a trade compliance practitioner, I'm a proud one, but if you could automate or use technology to not only automate, but to streamline all of those compliance procedures, now you can elevate the role of the trade compliance professional to focus on the areas that are deemed most risky. You're not classifying the same item 50 ways just because of its colorway. Now you're looking at the things that need to be looked at because there's a risk opportunity. In this case, we're talking about forced labor. So instead of auditing and surveying all of your suppliers and all of your products, maybe you're just looking deeply at the ones that are at risk of being exposed.
Let me ask this, Amy, and I agree with you, because as we're going through this, a lot of times the compliance specialist and whatnot has been rendered to almost a menial task, when in fact, if there's the use of automation, now they can apply their expertise to what's needed, which is the true exception. But all that said, right. Let me ask this question. Ana, from your perspective, how can somebody get, what do they need to do to become proficient in this, or at least have a working knowledge of what they need to do? Obviously, you can't memorize everything under the sun, but what do you suggest somebody does to get up to speed?
Well, I mean, I think that despite some of the claims from some of the private sector representatives, the government has done quite a bit at trying to put out information. I think that, you know, some of the expectations from business to have a checklist or to have some sort of a, you know, get out of jail free card, there is no such thing. You really have to do the hard work. And I think it's important to be able to get the message to the C-suite. And getting the message to the C-suite is It's not just about customs. It's not just about detention of the goods. This is getting into the Securities and Exchange Commission. It's getting into investors. This is going to impact whether or not your business is successful moving forward. If you can't police your supply chain sufficiently, it's going to be viewed as too high of a risk to put some money into, to invest in, and to keep listed into some of these markets. So it's the stakes are really high, much more than just not being able to clear goods. It really is reputational. It's economic, very financial. Partnerships is a huge deal. And so I would say definitely read all of the things that CBP is publishing. CBP and DHS are putting a lot of information. But if it seems too much, certainly there's a number of consultants out there that are experts in this area who might be able to help you.
Amy, what about from your perspective, especially with going to the C-suite and of what we've just been talking about in managing the data and all that, the ability to get proficient with taking in a message of what Ana was just talking about is like, okay, here's the regulations, it's at risk, but I would highly recommend that you say, here's where we're at. Here's what we're doing. Here's what we're importing or exporting. And that would come only way from, some very good managing of data in your supply chain.
Well, it's not even just managing your data, but seeing what you can't see today. So if you were to ask me where to start, absolutely be familiar with all of the great information that Customs is putting out there. But I would also say, call me. And I'm not beating. Call me. Please call me. Yeah. And if for no other reason than just to understand the art of the possible and how to get started with the technology, because we've tried really hard. A lot of companies are trying to make this really accessible. So let's say you were to call me up, Amy, I want to understand my risk exposure. I want to look at my top 50 tier 1 suppliers. We can start there. You start small. Learn and understand what your ecosystem looks like and where you may have exposure. And then once you understand that, you can take that action to your C-suite. And better than that, you can approach your C-suite as a cohesive unit, because now you can take that same information and partner up with it's trade compliance, partnered up with procurement, partnered up with supply chain, and you can work together and approach your C-suite with that information that way. That's how I would suggest getting started. And when I say call me, I'm not kidding. Please call me. And if you're not calling me, then you're calling somebody else that offers a technology that's somewhat similar. But understand what is possible. Inform yourself, because there are new tools, and it's important that the trade community know that.
For all those that are watching, we're going to be posting in the show notes the contact information and the bios for both of these wonderful ladies. But that's another thing, is that, again, reach out to somebody. If it's not you two, it's like, reach out. It's what I call bird dogging. It's like, if you got an issue, you got a question, you're needing some information, you go searching for somebody that can give you hopefully an answer in this kind of thing.
Thank you very much for joining us. Simply Trade is brought to you by the generous contributions of Global Training Center. You can follow the show and GTC on LinkedIn or Twitter and other social networks. Make sure you check out the show notes in the description for a full rundown of today's show with all the important links. Also, make sure you share this with a friend and subscribe on your favorite streaming platform. We really like hearing from you. If you enjoyed the show, make sure to rate and review wherever you listen to this podcast. If you or someone you know would like to be a guest on the show, or would like to sponsor Simply Trade, or suggest any topic you would like for us to discuss, please contact us via email at simplytrade@globaltrainingcenter.com, or you can DM us on Twitter at simplytradepod. Thank you again for the privilege of your time. Happy trading.